very warm welcome to everyone. I am Shrija Agrawal, and you're watching our series Demystifying Regulation in Technology. Our session today is on the theme The Changing Paradigm of Intermediary Liability. But before we deep dive into this August panel, let's do some context setting for the same. In this golden age of digitization, how we interact, how we stay connected, and how we constantly learn has been revolutionized and has been a key technological advancement for the globe. The internet's astronomical growth in India has meant there's an upsurge in online shopping as well as a rise in users on social media platforms. While that has been a boon in various ways, we have also observed many a bane and myriad of problems, be dissemination of misinformation, hate speech, and cyber threats. Now, this is a flip side of the same coin due to this escalation in unlawful activities. There have been incidents of mob lynching, misinformation about e-stations, and the coronavirus during the COVID-19 pandemic, sexual abuse, and more that have stemmed from this asset we call the internet. Now, there are intermediaries like social media platforms, search engines, blogging platforms, e commerce sites, and the idea they're just neutral pipelines for information and data is no longer sacrosanct. A question that has constantly been raised is, are these intermediaries to be held liable for unlawful content, products, or services that are posted on their platform by a third platform, and to what extent should they be prosecuted? According to the phenomenon of intermediary liability, these service providers could be held liable for unscrupulous acts of the users on their platforms, but this is something being hotly deliberated. In the US, there's been a heated debate about Section 230 as to whether an interactive internet service ought to be a publisher that can moderate or just a third party platform that let content be uploaded there. In Germany, for instance, there's a social media law to make platforms liable for the content that is carried. In India, there have been calls for the regulation of intermediaries to make them responsible for actively monitoring content and what they adhere to women and child protection laws. How the issues on these platforms can be regulated, can be combated, are contingent on what the gatekeepers of the internet plan to do, how they regulate online social media platforms, and how they mitigate risk for internet consumers. This really will be at the forefront of legal development soon in India. With growing calls for regulating these platforms in India, are we transitioning from a they didn't know standard to a they should have known standard? How severe should the teeth of intermediary liability be, and should it vary from circumstances to circumstances? Should they have qualified immunity if they do not physically aid and abet or conspire to perform an unlawful act, or should they have measures to prevent such aspects on their platforms? Or are they just becoming scapegoats for people to point a finger at because no proper solutions can be found? To break it all down, please help me welcome Supratim Chakrabarti and Anushka Sharda, partners in Khitan and Company on the same. Anushka and Supratim, thank you for joining and talking to me on this extremely important topic. Taking it further from where I left in my introduction remarks, I wanted to begin with you, Supratim. Really, intermediary guidelines. Tell me the relevance of it in the life of an entrepreneur who is starting out in 2021.
Right. I think the first things first, Shrija, the problem started with the definition of intermediaries itself. Okay. It's a huge bouquet. And I think the entrepreneur should look at it first from that perspective, that are they falling in the bucket of an intermediary? If I may just, allow me to quote that definition so that it's clear why I consider this to be the mother of all problems. It says that with respect to a particular electronic record, it means any person who, on behalf of another person, receives, stores, or transmits that record or provides any service with respect to that record and includes a telecom service provider, network service provider, internet service provider, web hosting service providers, search engines, online payment sites, online auction sites, online marketplaces, and cyber cafes. So you can observe from here that it is trying to cover the whole universe, starting from an internet service provider to a cyber cafe. So the first thing I believe that an entrepreneur should look at is, are they falling within that particular bucket of an intermediary? The next check I would say is to see that whether they are falling within the bucket of a social media intermediary. And thankfully, it has been clarified now better that who is a social media intermediary. It's basically an intermediary which primarily and solely enables online interaction between two or more users, or allow them to create, upload, share, disseminate, or modify or access information using their services. So what does that mean? That means that you could have, say, a side chat function in a fashion portal, okay, which is otherwise, say, selling clothes, etc. And but people are also, users are also able to chat amongst themselves to decide on the latest trend, okay. Now, if that is not primarily or solely enabling online interaction, and it is primarily for the sale of goods or services, then you are outside the purview of social media intermediaries. But if you are not, then there is a large chunk of compliances which come on you. And then the next check is that, are you crossing a threshold of 5 million registered users in India? The moment you cross that threshold, then the compliance requirements become quite magnanimous. And we'll speak about that maybe as we are discussing through this session. But I think that is where an entrepreneur should first look at that which bucket do they fit in. Okay, if they are not fitting into any of these buckets, fantastic. I think then all these compliances go away. But if it is the first bucket, it is, I would say, the compliance requirements are relatively lesser. As you become a social media intermediary, it becomes more, and significant social media intermediary, it becomes much more. So that's the, I would say, the first stepping stone that one should look at.
Thanks for that, Supratim. And this is very, very insightful. So essentially, the entrepreneurs have to look out for which buckets do they fall into. One key point that you mentioned, that perhaps I am not a media company at its core. See, I'm a med tech company, I'm a fintech company, I'm a fashion tech company, but I'm still using chat functions on my side for community engagement, for business development. And I still need to be extremely careful on what content I am reproducing on my website or my app, or being a third party platform what is being uploaded, right? That's what, if I've understood it clearly.
That's right. That's absolutely correct, Shrija.
Now tell me one thing, Supratim. The IT guidelines, when introduced, were criticized for sort of bundling together and seeking to regulate different kinds of intermediaries with the same set of rules, as if we have really bundled them and painted them with the same brush. What do you see are the practical implications of this?
Right. I think the first thing is that I told you the mother of all problems is perhaps the definition of intermediaries itself. And the first job which should have been done, to my mind, is unbundling this entire definition and seeing that we have different categories of intermediaries which are called out. For example, if it's a simple chat function versus, say, a Facebook or a Twitter, are also, let's take another example of, say, a chat function which is there as part of a normal business. All these are very separate, and their issues are also very separate. It should have been segregated better. Again, to give an example, players which are purely giving, say, video calling functions, okay,
Mm-hmm,
such
mm-hmm.
as Microsoft Teams, etc., etc. All these, whatever we are using these days, especially with the work from home scenario, this the usage has become sort of magnanimous. All of these have separate set of modalities in which they are operating. So you cannot, definitely you cannot paint them with the same brush. What has now been they've tried to do is that issue a set of FAQs where they try to somewhat segregate and say that, okay, the lens to look at this is perhaps uh, whether you are primarily or solely enabling such kind of interaction. Is there a possibility that you would have, say, a follow function, okay, or you can make a content viral? Are you able to meet strangers over such a platform? Things like those. So some bit of sense is being now tried to be built in through the FAQs to show that how perhaps the rigor of the law, which was tried to be implemented through the rules, is towards one particular set of intermediaries and not the others. It has come, of course, as a relief to some of the players, but again, it would have been better had it been in the formal law and not like in the FAQs.
Tell me one thing, Supratim. You work with so many entrepreneurs, you work with investors, under this ambit of intermediary guidelines and intermediary liability, which I think is still a legality, legally is still being developed. And we are tracing the development of this through this conversation. What the kind of cases or what the kind of problem areas that have come to the fore? Key concerns from entrepreneurs and investors, which have really, really been such bottlenecks in their development.
Right. I think the first thing is that, the uncertainty around some of these pockets or asks. Okay. Whilst I believe that some bit of due diligence to be exercised by the intermediaries is always welcome. And I don't think that entrepreneurs or intermediaries, they are averse to such a thought process. But, some asks without much of a guidance created issues. The mother of all problems you would have heard of is in relation to tracing the originator. Okay, where players say that if I have end-to-end encryption, how do I really trace the originator? The FAQs, we thought that we'll give some more flavor to it. What it does is it kind of talks about the end goal. It says that, well, I told you to trace the originator, and there are guardrails. I'll not ask any time and every time that you trace this originator for me, only after it is not possible to be found out through other modalities, and after we have followed all procedural safeguards, that we will ask, say, an originator of an information to be told to us. The point is that they're saying that we are not saying that you reduce security, you remove your end-to-end encryption. How you reach there is your prerogative. I want the information after following all protocols or correct processes. If I asked for it, you have to provide it. I think so. This is one large issue. There's another set of issues which was I think primarily where entrepreneurs and intermediaries struggled, is the appointment of three officers. They are saying that you need to have three kinds of officers now if you are a significant social media intermediary. That is, you have 5 million or more registered users in the country. You need to have a chief compliance officer. You need to have a nodal contact person. You need to have a resident grievance officer. All these have to be resident in the country. The problem also emanated when they say that a chief compliance officer, say, can be held responsible in proceedings in case the entity is not following the requirements which are set out in the law. So what happened for entrepreneurs and intermediaries is to figure out such a person. Okay. And to see that this is the right candidate, having the right acumen, well placed in the organization, so that the person can actually take calls on this critical issues. They can be called in by the authorities, etc., etc. So all of these, I think, so appointment of these three officers was a key challenge. Another, a relatively smaller one but large for, say, I would say, foreign players, is to have a contact address in the country, which is also a requirement under the rules. Now what happened is, when you talk about having employees in the country and an address in the country, there are also other aspects which one should be mindful of, which is, say, tax oriented. The question is, did the authorities really think through of such issues, that there could be a tax implication for such players who are suddenly deploying three officers in the country and having an address to receive communications, all of that. So I think these, in a nutshell, I saw as large issues.
Thanks for that, Supratim. Anushka, I would like to sort of bring you in now. You have been patiently listening to your colleague. We spoke about this entire fiasco around the intermediary definition itself and how that needs a lot of unbundling. Supratim spoke about the fact that you can't paint all the intermediaries with the same brush. While the core functionality could be different, there could be side functions, but they still all come under purview of intermediary guideline. And very important fact on the practical challenges of understanding this, you need to have three officers, chief compliance officers, and it's not really about salary for these startups which are so well funded. The very fact the chief compliance officer can actually be held liable for some of this is a huge ask. I wonder what really is your viewpoint in some of these areas.
Yes, Shrija, very valid point. And especially, I'll start with the last requirement that you mentioned about appointment of a chief compliance officer. I think this leads to a twofold problem. One is obviously putting the entire burden on a person who practically may not even be the decision maker. So if we really think about it, there are these companies incorporated in, perhaps the US or UK. And are we really saying that this chief compliance officer sitting in India is taking all the decisions regarding what content should be uploaded or taken down, from these platforms? So is the law in touch with reality, and or is this person just being made a scapegoat? That's one. Two, is the requirement to appoint a chief compliance officer and making him liable in all proceedings for non-compliance by this intermediary going to result in over censorship? So if the chief compliance officer is in reality a senior personnel, which is required as per the IT guidelines, and is the decision maker, if I would be in the shoes of this chief compliance officer, perhaps I would start censoring any content which I'm doubtful about, because there are serious consequences under the IT guidelines for non-compliance. So, the debate between over censorship versus rights of freedom of speech and expression and public safety are endless, and there's no clear answer over here. But I think my biggest concern is regarding the requirement to appoint a chief compliance officer.
Thanks for that, Anushka. So, Pratim, I want to sort of get you in here. She made one expression, and it's an interesting one. Is the law in touch with reality? If the law is not necessarily in touch with reality, what do you think should be the thinking lens or should be the guiding lens for the lawmakers when thinking about intermediary guideline liability? The fact of the matter still remains that you can't make an innocent person a scapegoat, extremely liable for things perhaps what rightly pointed out, does not necessarily understand, does not necessarily know, and perhaps is not necessarily the chief decision maker too.
Right. Fantastic question, I would say. And this, I think, we should answer from the lens of lawmaking in general, especially in the digital space, which we are observing right now. Okay. If you would observe, Shrija, we are doing a lot of knee-jerk lawmaking right now. If we have problems with social media intermediaries, we are spraying social media intermediary related aspects into multiple laws. You would have heard about the personal data protection bill, which is now having a prominent pillar in relation to social media intermediary. I don't know what will be the fate of it, but I can tell you that when we started the journey, it was supposed to be an umbrella legislation for data protection. It cannot have granular details such as social media intermediary in the scheme of things. It will fit in through laws such as, say, the Information Technology Act and the rules therein. Now, even under the granular laws, how do you treat this? Because technology is so fast paced, it is moving so rapidly, you cannot put in granular details. You have to make it umbrella as well, so that as things evolve, you will still be able to fit in the developments within the principles that you have laid out. So it should be principle based approach rather than trying to say specifically what should go in. For example, this threshold of 5 million, which is 50 lakh users, registered users in India. Now, apparently, this has been taken from some German law. Now, in Germany, maybe 5 million registered user is a big thing. But in India, you cross that threshold in no time. And it's not monthly active users, which intermediaries or entrepreneurs were saying that please come down to something which makes sense, right? If it's an because many there are millions of people who will just log in and never after the first time perhaps log on to that particular portal again, but they become registered users, right? So there is no guardrail there for them to be not considered to be registered user when when an intermediary is getting categorized as a significant social media intermediary. And let me tell you, the compliance requirements are jumping up magnanimously. So these are small things which and therefore in the lawmaking, what I believe is create an umbrella legislation. Let there be ample scope for self-regulation. Okay, you create the broader guardrails and let the industry flourish. if you really want India to grow in the digital space, that's how your law should be more enabling rather than restricting.
This is so well said, Supratim. You made some very important remarks. You said a lot of knee-jerk lawmaking is happening, just given digitization is so fast-paced. Doesn't and technology is evolving so fast, and clearly regulation is not being able to keep pace with it. And exactly why we are having this series with Ketan and company, demystifying the RegTech conversation. And you also said that perhaps it's time for self-regulation rather than very granularly laying out the specifics, because you can't really do that. And this 5 million thing is a pretty interesting number. I mean, 5 million in India and Indian startups, given the population that we have, I think it will be sort of very foolish to sort of just take something from any other country without understanding the space, the relevance, the time, and the context for it. The context is extremely important. Anushka, I wonder what really are your comments onto what your colleague just said in terms of knee-jerk lawmaking and perhaps having a more umbrella view on things than a very granular view.
Right. So, especially considering I'm a disputes lawyer, so just bringing in, the judiciary over here. So every time a new law is framed, of course, it goes through a process of judicial interpretation. And it's only at the end of that which when we actually understand how is this law going to be implemented and how is it going to actually play out in practice. So the same thing has happened with these intermediary guidelines. And a lot of the issues which were pointed out by Supratim are being debated in court as of today. For instance, whether the requirement to identify the originator of information is constitutional, or does it violate one's right to privacy? Is it impossible for end-to-end encryption and the requirements imposed by the new IT guidelines to work hand in hand? If not, is it viable to seek that these intermediaries change their application architecture, which may in fact compromise user safety and user privacy? So these are issues being fleshed out in courts as of today. Secondly, there's a requirement for significant social media intermediaries, which, as we discussed, has a very low threshold of 50 million users to take down certain kinds of content within 24 hours of reportage. Now, in practical terms, a startup, will it even have the wherewithal to react within 24 hours and start taking down such kinds of content? So, and this is the reason why perhaps Germany imposed this obligation on entities of a certain size, which is perhaps not true for India. And that's, I completely agree with what Supratim and you were discussing, that having a threshold of 50 million users, considering the kind of compliance requirements under these guidelines, is highly impractical. Another very interesting issue which is pending before courts today is one of the guidelines which requires that any content which may be considered by any individual as being harassing, as harassment, can be reported to the intermediary and needs to be taken down. So, in fact, this is the only requirement. Why I brought this up is this is the only part of the guidelines as it is applicable to intermediaries, which has in fact gotten a protection against enforcement by Madras High Court. The rest of the guidelines are challenged, but while notice has been issued, no protection has been granted to intermediaries against the guidelines.
Thanks for that, Anushka. So we spent a bit of a time understanding the scope of challenges pending before courts and what really is the expectation. We also spoke about the lens, the thinking lens, and how the lawmakers should look at some of these areas. And some very interesting ideas came to the fore. I really loved the expression, the knee-jerk lawmaking that is really happening in this golden age of digitization, and how lawmakers should look at it. A self-regulation is perhaps looks like as consensual as the way to go forward, but it's a different conversation altogether. And now that we are sort of doubling down on intermediary liability, interesting developments have happened. To be fair, some intermediaries have actually been called out for allowing hate speech and other forms of objectionable content to be circulated on their platform. My question is that, so are these intermediaries required to be vigilant and proactively filter such content? Or is it their obligation to take down content triggered on receiving a complaint? Why can't it be more proactive rather than having a very carrot and stick approach to this? So, Pritim, perhaps I would like to hear from you and then Anushka.
Right, I think I'll get started with this, and let us go back to the whole philosophy of an intermediary. Okay, that is basically saying that you are a dumb container or a dumb pipeline. I really loved, one of my close colleagues and friend, really helped us, in devising these terms. But what happened over a span of time is that we do not remain a dumb container or a dumb pipeline. The government wants the intermediaries to look into the container and into the pipeline and see what is there. I'll let Anushka really deep dive into what is the real ask of the law. But what I believe is that there should be, a judicious approach in when these intermediaries are being told to look into the information and decide what should be there and what should not be there. So over to you, Anushka.
Yes, Anushka.
Yes, this is actually a burning issue right now. Whether intermediaries should be required to proactively filter content or not. Now, just taking a step back and on how this entire regime started. So if we all, I think all of us remember the Bazi.com case in 2008. This is where it all started. Mr. Avnish Bajaj was criminally charged for not filtering content which was available on his platform. This is what led to the IT Act being amended and safe harbor protection being introduced for intermediaries. So this is, of course, when he was criminally charged, understanding of how intermediary platforms work was very low. It was very nascent at this stage. Safe harbor protection comes in 2008. The due diligence requirements for intermediaries are prescribed in 2011, which basically require intermediaries to take down content once they receive actual knowledge of it. Now, it was very unclear as to when do these intermediaries receive actual knowledge. This is where Supreme Court stepped in 2015, and the celebrated judgment of Shreya Singhal was passed, which said very categorically that when a court order is passed or a government agency notifies an intermediary of objectionable content, only then the intermediary is required to take it down. Now, what was the logic behind this? It was twofold, essentially. One, court said, we don't want private citizens and intermediaries to be deciding what content is objectionable or not. Basically, we don't want them to be censorship bodies. It should be either the court or a private or a law enforcement agency which determines whether the content is objectionable or not. Secondly, they said it is impractical to expect intermediaries which are dealing with millions of posts to actually scan through this content, screen it on a daily basis. So for a while, there was what was called a blanket protection, perhaps to intermediaries against content on their platform until and unless it was reported through a court or a law enforcement agency. Now, this now brings us to the IT guidelines. And this is where I think now we are taking a full circle. It started with Mr. Avnish Bajaj's case in 2008, safe harbor protection, Supreme Court saying you don't have any requirement to proactively filter content. And now we've got the 2021 guidelines where the legislature said, no, hold on. there may be some categories of content for which intermediaries need to proactively filter. Now, that category is well defined to be child pornography and rape. They haven't extended it to other categories. This is also required only of significant social media intermediaries, obviously, because their reach is much more. And thirdly, even now, the requirement is not binding, so to say, till a court perhaps interprets it to be binding. The law says that significant social media intermediaries have to endeavor to take down such content. So the standard is only to endeavor. It's still not mandatory. So this is the law as of today. But I must also add on, every time a case is filed in court, regardless of whether it is filed against a social media intermediary, significant social media intermediary, or a search engine, the ask is to proactively filter content once reported. Now, whatever be the guidelines, courts have passed cases asking intermediaries which are not significant social media intermediaries as well to proactively filter content. All these orders are in challenge. They, saying that it's not technologically feasible or that there's no legal sanction behind this. But courts have shown some judicial activism in this field.
Thanks for that, Anushka. Supratima, I sort of come to you, sort of very clearly sort of laid out by Anushka, and how we have sort of come full circle, especially with the coming of the IT guidelines and how it started to where it is right now. 2 or 3 key points that she mentioned, I made sort of notes of. Some categories of content have come under scanner, that you need to proactively filter content on those areas, but that does not necessarily extend to a wider spectrum. My question to you really is that, is it actually possible for these larger social media platforms to self-regulate and proactively filter content, just given the mammoth size of what they're dealing with? Is it really possible? And is it a playbook that we can follow on this, where actually the law is in touch with reality, where it is absolutely practical what we're talking about?
Right. I think, Shrija, the way to look at it is like this, that at least for the larger players, there are other methods, modalities which are available to them, like having AI algorithms to figure out some of the contents which could be ordinarily understood to be vulgar, content which should be taken down, immediately, all of that. But what happens is, sensitivities differ from jurisdiction to jurisdiction. So sometimes maybe if something is applicable at a global level, and they generally would train their model basis the global model that they would have, it may be very different for India. And India, you would understand the sensitivity sometimes are so peculiar and nuanced that a global model will never pick it up. So as we go along, I think intermediaries will have to spend some more time in the sun in India, and understand the Indian sensitivities, create their model around India, train them, and it should be a little better, say, safe sailing. Now, coming to the realities and the practical approach that should be taken, I believe that the way digital laws are progressing in the country, again, demonstrating compliance is becoming a very big thing. You tried, you reached 80%, 85%, 90%. That should be a decent veil for you, safeguard for you to at least put up the defense that I tried, but it could have failed in this particular one case, okay, or few instances. I think that is what should be the and that's what I think the government is also looking at. If you hear them, the ministry folks, in several instances I have observed, that they have come to terms with the fact that there could be some slippages, but did you demonstrate compliance? Did you try at least? Okay, it's not that I completely raised my hands and said I would not be able to do it. In fact, when this whole set of rules came in on social media intermediaries, and there was one set of requirements which triggered after a certain period of time for significant social media intermediaries, the government sent out letters in relation to such significant social media intermediaries, and they asked two critical questions. Have you appointed those officers, those 3 officers that we spoke about? Do you have that registered office? And of course, how are you otherwise complying with the set of rules? Is an omnibus question. So it's very clear that I want to know, the first things first is, do you have the people whom people can reach out to if there is an issue? Okay, is that in place? Is the contact address in place? And otherwise, just tell me how you have been faring and trying to, be compliant with the new rules.
So fair. So essentially, the effort is also being factored in, that how much effort you're putting into your compliance. My same question to you, Anushka. So Pratim sort of clearly laid out and practical example that perhaps there are AI algorithms which can look at self-regulation, proactively filtering of content. But very important point that he mentioned, the sensitivity question in India is varied and myriad. Just the kind of size and the uniqueness of our country, given we're such a culturally rich country, we take pride in so many things that we are, and rightly so. But at the same time, we're sensitive about quite a few things: race, caste, color, language. And because we are a country of different states, very large, which perhaps might not be the situation in different countries or very size of economies you're dealing with, what really the practical kind of solutions which you envisage to deal with something like this, which you might have heard or are in discussion with right now?
Actually, I'll answer 2 points over here. So, one was about how industries are approaching proactive filtering of content, and what Supreme mentioned, that as long as they can show that some effort is made, perhaps the government will appreciate that and not take it further, which is exactly how it's playing out. But one issue which is also pending in courts is the stand taken by some industries that it is absolutely impossible for them to proactively filter content or to even take down any content on it being reported because of end-to-end encryption. So this is a sticky point, and ultimately, Supreme Court will have to decide it, because obviously the companies which are claiming this cannot show any effort towards proactive filtering of content or takedown of objectionable content. Now, coming to, I think, is the second very valid point of different jurisdictions across the world treating the same content very differently. What may be tolerable in the US may not be tolerable in an Asian country, for instance, any country. And what may be considered, like, in fact, things like defamation are so subjective, and that is what is generally, in the eye of the storm. So, in fact, Indian courts have dealt with such issues. There was a case of Swami Ramdev versus Facebook, which was before Delhi High Court, where exactly this issue arose, that, okay, this may be considered to be defamatory in India, so let us only take down this content in India and let it be available globally otherwise. So that's how they generally deal with such issues. But court went a step further and said that you may geographically take down, but because of VPN and proxy servers, this content may still be available to Indians. Therefore, geographical takedown is not effective, and you need to globally take it down. Now, this is again pending in appeal, because, as you said, is it to require an intermediary to take down certain content which is acceptable in another country, and taking down that content may in fact make the intermediary liable for over censorship in that country. Is that fair? So that's something which the appellate court is considering, and I think we'll have clarity in some
Thanks
time.
for that, Anushka. So essentially, what is defamatory, perhaps in India, is not necessarily so in other countries. And you give an example of Ramdev versus Facebook. My question, and what I'm understanding perhaps, is an interesting idea which just popped my head. Perhaps it could be a startup idea, a startup in India, which can actually help intermediaries filter such content. But I'm just wondering, is it really possible with AI also? Because this area is so subjective. It really requires content moderation at a scale of billion posts a day or a million posts a day. And I'm not really sure an AI, or no matter how intelligent an AI is, that can really do, because ultimately there could be biases and human biases also in play in this. That is one. My second is, one of you sort of mentioned, I think Supratim, you did, that the law is appreciating the effort at least. So, is there compliance washing happening the way greenwashing was happening? Because ultimately the problem at hand is not being solved. You are being appreciated, scapegoat is there. So is there compliance washing happening, for the want of a better word, just the way we saw in the entire ESG narrative? A lot of greenwashing happening where every company labeled itself to be green. Because I don't really see and understand that the startups really, who have so much more priorities to deal with the investors, to raise another round of funding, really have the wherewithal, the understanding to really come clean or sort of be very, very proactive on this front.
Great question, and I think a very practical one. I'll make it even more difficult. There are some more players who don't know how to and what to follow. For example, these audio-based social media intermediaries which have come. What do you take down? When do you take down? Because it's happening almost instantaneously, right? So that's one. Coming to the question of level of compliance which is happening, can we fix and forget? Answer is no. It has to be really a continuous process. It is a journey. Okay, every day is a new learning, and one cannot really again fix and forget about it. So therefore, there are gold standards. There are global gold standards which can be emulated, but you have to literally have a team which is constantly working and at it all the time. To my mind, you would need a lot of effort, resources to be put in if you're really serious about these requirements.
Thanks for that. I think we spent quite a bit of time on practical implications and what really are the efforts and the ways in which this can be met or mitigated with. Now, let's talk about some of the cases which have come to the fore, where some of these interesting judgments have passed and which got people to think. The recent one, which I understand, is this Delhi High Court, Mrs. X versus UOI, passing a judgment asking search engines to endeavor to proactively filter content. Now, how does that interplay with the new IT guidelines which prescribe this obligation for significant social media intermediaries? Anushka, want to take that up, and then I go to Supratim.
Sure. So, like we discussed, all intermediaries have been bundled together, and an attempt has been made to regulate them under the same guidelines. The task of the legislature is unenviable. Of course, they cannot, segregate each intermediary and perhaps introduce a separate set of rules for, search engines and social media intermediaries and proxy servers. But what's happened as a result of this is often courts are imposing requirements which are perhaps meant for other kinds of intermediaries on, search engines. And that is the wrath which Google was the search engine in this case has faced, because there is no requirement in law for a search engine to proactively filter content. In fact, search engines don't even host content. All they are doing is indexing content hosted by other platforms. But template directions have been passed in this matter, saying that without requiring Google to actually proactively filter content, the purpose of taking down content is being defeated. You cannot require a user to keep reporting links to Google 1,000 a day, every day, and be so vigilant, and then have Google react. Once a piece of content is reported to Google, as per Delhi High Court in this judgment, they have to start proactively filtering it. And court has gone a step further, and in this judgment also held that it's not feasible for Google to only geographically take down content. It has to be global takedown, because without that, it's not an effective takedown.
Thanks for that, Anushka. We're getting towards the end of the conversation. My question to this sort of very meaningful panel, and both of you are specialists in this space, is that we spoke about the solutions on how possible this is, and it comes and appears to me, and please correct me if I'm wrong, that as of now, perhaps there's no practical solution to it, right? We have to deal with the problem the way it is, and I think this is only going to increase given the amount of money that is coming to India into this tech startups, which means a lot of money for law firms like yours, getting them to understand and making sense of the law. But practicality, the kind of damage that is done to the freedom of expression, the sense of expression, uh, how does one deal with that, Supratim, really? How free we are then to post the kind of content that we want, especially in a country like ours, where there's hate speech on so many aspects, on race, color, religion, caste. I really wonder, and maybe it's a question different from the legalese, but really, I mean, it's a very important, a burning question to address now. Hate speech, it's increasing on a daily basis. Is there practically a solution to that?
Right. I think whilst you're absolutely right, Shrija, whilst we are trying through different modalities, and one of the modalities you would have just read about is saying that you try and have a mechanism to identify the individual. Okay, so you have a self mechanism where you can identify yourself and say that, okay, it's an authorized, identified person who has opened this account. And then sort of see that can you really pluck out people who are not registered, who have not given the relevant details for registration, and accordingly, if such people are there, they are trying to put up information which are in the nature of say trolls, etc., then the platform becomes liable. So we are trying various modalities again, carrot and stick, like you were mentioning. I don't think any of these are foolproof, and sometimes this can actually be quite detrimental for an entrepreneur or a platform where they were perhaps not really on the wrong side. What we have to do is really mature as an ecosystem. It's been some time that we are all on various social media platforms. The behavioral aspect of it needs to come to us as a society at large. We can keep trying to curb it through laws and regulations, but that alone will not suffice. We have to bring in a culture where we understand our responsibilities, and that is how it will be a better solution, really to have at hand, rather than just trying to curb these menaces one after the other. And like you were mentioning that is this going to increase? My fear is that it is going to increase, and it is going to also proliferate into different kinds. So it's not a old problem which is increasing, it's an old problem perhaps which is increasing, and also there are variants, just like your you know the virus which is now showing different kinds of variations. So that's the problem, because every day you have to keep thinking, what is the solution to this new problem as well? So if we have to really address it, we will have to mature as a society to see that all this is not happening, and we are putting up content which is pre-measured from the individual side. And like I was mentioning, there are audio platforms. What curb will you put there? Because someone has already shot the bullet.
Wow.
So after that, whatever you are doing is damage control. That's it.
Absolutely. Anushka, any thoughts on that? Concluding thoughts on this one?
Yeah, no, see, I don't think there's any perfect solution, but I think we have taken some steps forward. Of course, it's a growing menace, so how much ever we do, it will, appear as if it's less. Tech will always outpace law, but as we are understanding a little of the use and misuse of technology, at least these 2021 guidelines are a first step, and hopefully the next set of guidelines won't come after 10 years. Before 2021 guidelines, the previous guidelines were issued in 2011. Hopefully there will be constant thinking, and it will not all be left to the judiciary to constantly plug the loopholes. I don't think that's the healthiest approach. The legislature should be constantly, at least in the tech space, coming up with new guidelines. And yes, like Suprita mentioned, you can identify the perpetrators and perhaps pull them out. That's also very difficult in the tech space with the kind of encryption. Many entities will not be able to identify the perpetrators. But yeah, there's no perfect solution. But I think at least making intermediaries accountable to take down content which is reported to them, introducing timelines under the new guidelines within which they have to act, is a step forward in addressing the issue.
Definitely. So consistency in regulations is one. That is clearly consensus. Both of you have really sort of doubled down on that. One thinking that's Supratim, I was just sort of thinking is that why can't what is right or what is wrong? What has to be regulated? Why can't the government decide that? Or, for instance, data protection, we have this independent authority being talked about, being given so much power. So, in terms of content, why can't we have one supreme authority which tells you what is of nuisance value, what is not necessarily of nuisance value, which perhaps is very India centric and seemingly addresses the concerns and factors, sentiments of a diverse nation as ours? Is it practically possible, do you think?
I have been part and parcel of the data protection, which will perhaps look at now personal as well as non-personal data related elements. Perhaps that itself seems like a daunting task. Okay, where we have some global templates, we can fall back on international, jurisprudence, etc. Some in some context. This element aspect that you spoke about would be extremely difficult for a country like India. Whilst there is a thought process which is brewing on similar lines like you have mentioned, but to my mind, it is without any kind of guardrail, without any kind of boundary. So to have such an authority to really even not even regulate, even to guide, I would say it's a little difficult. Maybe we can start thinking if we can be the leaders in this space globally, like we are in a way doing for non-personal data. By the way, we have very little precedent internationally. We are trying to do it in India. So, but this will take time. This definitely will take time if at all it becomes a reality.
Okay. My question to you, Anushka, is that this is a bit different one. If you were to advise, say, a SoftBank or a Tiger Global, which is investing huge rounds of funding, and that is the ticket size that they raise, $100 million, $200 million, into a social media company, into a networking platform, what really will your advice be to them? Because, first of all, a lot of funding is happening without even a fundamental business idea. We don't necessarily even know that these business can absorb this amount of capital. Do you really think that at a time when deal making is such a competition between VC firms to who is the first, who is the second, are they even thinking about some of these aspects which can really make or mar the trajectory of their portfolio company?
Yeah, I think I'm less of a pessimist when it comes to the growth of the platform economy in India. From the point of view of a venture capitalist, I think India is a great space to invest in, especially when it comes to technology. And while there are lots of undecided issues, there are more problems than solutions anyway. But the sense I got was that while there are stringent guidelines, and if you read the penalties, you will think it's an absolute death knell for the platform economy in India. But the practical approach is very different. The moment you maybe fail to comply with a guideline, it doesn't mean that the chief compliance officer is being put behind bars and the platform is effectively stopping operations in India. That's not how it is practically working out. So while these safeguards have been introduced, I think practically the way they are being implemented, except of course there are one or two cases which stand out, but I'm talking about generally how it's being implemented. it's looking positive to me. I think the government and the landscape is moving in the positive direction.
Okay, Supratim, your colleague had a pretty optimistic point of view, despite she herself saying that there are more problems than solutions. I really wonder, Supratim, what would be your view?
I definitely want to come in here and share some of my thoughts. Shija, when these small startups they start doing business and they do phenomenally well, right? They go places, okay, and they're going to several jurisdictions. They're also proliferating quite rapidly, increasing user base in the country. Sometimes what happens is maybe not too much attention is paid towards compliance, and they would have been missing it. But what we observe is that when these rounds of investments come in and there is due diligence which is done, when we are able to pick this up and tell them round by round, we see that there is so much development on the compliance side that by the time you become a mature player, you are also very good with your compliance, which at par with international standards. So I definitely not think that this is a negative thing. This is a positive thing, because every time you are having this investment, someone is also looking into your system very granularly.
So great. So the ecosystem on totality is developing, and perhaps investing in compliance is a very better and well-informed decision for startups. It only helps you become a better company at the end of the day. Oh, what a lovely conversation, a topic which people might seemingly think is niche, but actually is at the heart of everything in the platform economy right now. It's time for the mandatory rapid fire, and I can't let you all go without that. My first question to you, Supratim, and I know you have worked on the data aspect very, very well. Initial reactions to the entire bill. I know it is going to be presented in the winter session. Initial reactions, what really are you sort of gathering? What do the experts like you have to say at the first blush?
I think there are few items which have been brought in which should not have been there. We worked on it since August 2017. When we set sailing, I think the parameters, the contours were pretty much clear. We worked on it. Some refinements were required. But right now, some additional points which have been lumbered, like I told you, say non-personal data, uh, social media intermediaries, things like these, they should ideally be kept outside. This is a data bill. Let's treat it like a personal data protection bill only. But minus that, I think I'm very positive and upbeat about the law. It should get now passed.
Okay, the future of platform economy in one sentence in India.
I think it's positive, positive, positive.
Okay, one overhyped unicorn according to you in the current scenario.
No comments, sorry.
Okay, I come to you now, Anushka. The same question to you. The future of platform economy, according to you, what do you think?
No, as I said, positive, and everything is now going to be, driven through platform economies. So there's no running away from it.
One advice to lawmakers on how they should be looking at platform economy and such allied activities. If you were to sort of crisply give me like one sentence, what would that really be?
I think increase consultation with the industry before lawmaking.
Okay, thank you so much, Anushka and Supratim, for that. We had some very interesting ideas come to the fore. Reduce knee-jerk lawmaking, increase consultation with the industry, practical implications. You have to be in touch with reality. What can startups really do to sort of really get there in terms of compliance, advice to investors, and what not we discussed. Thank you so much. Till time I see you next, goodbye and good luck. And keep watching the Mint Ketan and Company RegTech conversation. Thank you.
Thank you.